Good evening. Every Tuesday, we do bring in immigration updates and we do take live questions from 5 to 6 p.m. Central Time every week. Emily, what do you have today to discuss?
Well, people are facing ongoing issues with obtaining visa appointments in India, particularly for H-1B and H-4 visa stamping. So, a lot of questions are coming up on what other options are available. Specifically, can you apply for a B1, B2 visa in order to come into the US instead of waiting for an H1B or H4 visa appointment to become available? So we'll talk about that. Also, April 2026 visa bulletin came out today. We saw a lot of forward movement again in EB-2. Filing dates also moved forward. And we can use the filing dates for April. Why are we seeing this forward movement? What does it mean for people? How should people prepare as we're getting closer to where we were back in October 2020? And then because of the delays in green cards, we're of course seeing more and more kids who are brought here on H4 or as dependents, ending up aging out of the process and having to convert to F1, and then sometimes even to their own H1B. So, what does that path look like as teenagers move into their early careers in the United States, remaining here? Lastly, we'll talk about using your green card EAD, the C9 EAD, based on your pending 485, or staying on H1B. Especially in a bad job market, which one is the safer option right now? What are the pros and cons of both of them?
Emily, first thing, B2 visa, if the visa appointments are not available for the F1 and, sorry, if the visa appointments are not available for H1B and for H4, though, is a bad idea. You should not, because your purpose is not to visit United States. Your purpose is to actually stay in United States, work in United States, or stay with the spouse in United States. So you should not use the B2 at all. You should not use the B2 application at all. We strongly recommend you don't, because it will have long-term negative effects. You may be barred forever to come back into the United States. Or even if they deny the B2, there is a good chance that they will have a negative impact on the H4 and H1B and H4 at a later date when you get an appointment. I do get a lot of calls saying that my wife is pregnant and she's in USA to deliver the baby. I understand the situation, but that doesn't allow you to do some wrong things, though. Because it's like, people will say, okay, my mother is sick. Can I go rob the bank? Answer is no, obviously. So it's very similar to that. We can't suggest you to do unlawful activities. We sympathize with you. We understand the situation, but still, we don't want you to do wrong things. Emily, you have any different opinion on it?
No, I agree. I mean, if you are, these officers do know your immigration history. Obviously, you have to fill out a lot of information in the DS 160 visa application. So, most people that are facing this situation have previously been in the US on H1B and H4. Maybe they left to apply for visa stamping last December, got their visa appointment canceled, and now it's rescheduled for sometime in 2027, or people who had to travel and just aren't able to get an appointment at all. They know that you were previously here on H1B and H4. That means the likelihood that you are coming to the US for pleasure, for tourism, or for business only is quite low. You've built your life here. You don't have those same ties to your home country that you once did. You've got a job in the US. You've been working here. So the likelihood of you getting the B1, B2 is very low. On top of that, the risk, as Raul mentioned, is misrepresentation, which is a ground of inadmissibility, meaning they can use it to deny any future visa application. They can use it to deny your green card if you are purposefully misrepresenting the reason that you are applying for this visa, the reason that you're coming into the US, when in fact your real reason for applying for this visa is to be able to come and pursue the H1B and H4, because visas appointments are unavailable. So it is a real danger and definitely should not be considered an option.
We definitely discussed the visa bulletin that the priority dates have moved very significantly for EB-2 and EB-3. We may see some more improvements going on the priority dates as we move forward, especially in the visa bulletin of October of 2026. We're expecting a lot of movement in we are expecting a lot of movement in there. For those people who are contemplating and jumping the jobs, probably this is not a right time, because if you join a new job, you may not have a new labor certification I-140 with a new company so that you can file the adjustment of status. There are under special circumstances, you can file with the old employer, but the old employer has to cooperate, to which 95% of the old employers since you left the company may not be willing to do it. The good part about the visa bulletin for April of 2026 is that they are still allowing the filing dates. It's surprising, Emily, that normally they do filing dates very early in October, November, but not in the month of April, March, April. They're
Mhm.
still allowing it. What does that show though to you?
Yeah, that tells us that the number of people that are using employment-based green cards outside the US at consulates is quite lower than they anticipated, and therefore those green cards are not being used by the rest of world and can be spilled across to whichever country has is the most backlog, which is India in EB-2. And so, why are people not seeking the green card through the consulate like they normally would? Mainly due to the travel bans that are out there that limit people from certain countries to be able to apply for any immigrant visa. So, we've talked a lot about family based green cards not being issued and those spilling over starting from October. But again, those won't be available till October. So, why are they moving the dates now? That's because the employment-based green cards are also going unused at the consulates. On top of that, there are countries that have a benefits pause, meaning that you can be in the US and you can file your 485 if you're from one of these countries, but USCIS won't approve the application. So they won't be able to use a visa number for that person. That opens that number up for someone else. When we're talking about that spill across, the 7% cap no longer counts if there's visas available that the rest of the world isn't using up. So that appears to be what is causing this. And they are knowing that current processing time is maybe around 9 months average. And if they don't take in the cases now, they won't have them ready to approve by September, which is going to be when this year's green cards go away. And so it looks like USCIS is actually planning to hopefully make sure that they're actually using up all of the available green cards this year. We still don't know how many we have because they haven't told us the spillover from family based last year, on top of these employment-based green cards that are currently going unused outside the US, or adjustment of status applications that cannot be approved inside the US due to that benefits pause.
We have seen a significant amount of jump in the month of March, almost 11 months jump. We have seen a significant jump, 10 months jump, and the clear jumping is because the filing dates have moved to January 15th of 2000 and January 15 of 2015. In 2020, though, the priority date moved all the way to January 1st of 2015. And since that time, since the past 5 years, it hasn't moved beyond January 1st of 2015. This is the first time it's moving. They have cleared up some of the cases. It seems that there is low demand for the other than Indian nationals. That's the reason why Indians may get more number of green cards this year. And as Emily has pointed out, family immigration may not be fully used. So there may be a lot of movement. Do you expect the same kind of movement, Emily, like 10 months, 11 months every month from now onwards?
I don't think so. I think they have moved it forward pretty far now, again, to get in the cases to generate that demand so that they can use up all the green cards. But I don't think they're going to be able to keep moving it forward. I mean, just looking at the numbers, again, we don't know the total available. We don't know how many are no longer being used by rest of world due to not being able to obtain green cards at the consulate or the adjustment of status benefits pause. What we do know is between September 2013 and July 2014, that's how the dates moved in EB-2 from March to April. There's about 14,000 485s in that group right there. That's a huge number for them to move when EB-2 is normally at a much lower number, 2,800, due to the 7% cap. So I think that this is kind of a one-time movement to get us through the rest of the fiscal year, so we can make sure that we don't waste green cards, and then we'll see another jump in the October visa bulletin. Of course, that's a guess. You know how many times we're wrong on these things. We definitely didn't predict this movement for the month of April as well.
Going to the third topic, people who are on H4 visa, teenage kids, and if the priority date may not move for them, they need to be prepared to move to F1 visa. They need to be prepared to move to the H1B visa. I know when you came into United States, that's not how we taught the kids. We thought that, okay, you will be part of the society. But in countries, Middle East and some other countries, so they never give green cards or citizenships. So definitely we need the teenage kids to be educated that you are not born in United States and you will have to face this difficulty when you go up. And they need to be trained. We want them to be also tuned in for the YouTube channel that we have, because it's very hard. A lot of I see my own some of the family friends that I have. The kids are definitely, they are immune. They don't want they completely want to ignore this. Now, when there's a sport event, though, the whole family watches together. The whole family is interested. Of course, this is not an entertainment what we are doing here, but we want the kids to be involved in in this entire immigration process. You need to educate the kids. You need to tell them, look, you are not a US citizen. You are not a green card holder. You need to go through this process. And there are a lot of ups and downs that will be going on. And the people need to understand their own process. It's not like you tell them, they just understood it. Oh, yeah, yeah, yeah. That doesn't work that way. You know it. If you just are not vigilant for 1 week or 10 days on your immigration, you may lose a lot of things. So definitely we want kids to be. Now, for the H4 people, they can move to F1 and they need to move to the H1B. This is the normal process for them. A lot of people ask question, hey, my kid moves into F1 visa, if the priority date becomes current, can I still file the 485 for my child? The answer is, if the child fits into the under 21, there is a CSPA exception which may give some exception for a couple of months. They are still eligible to file the 485 even if they are an F1 visa. When are they not eligible to? If they get married before 21, I mean, not many people do, but yeah, if somebody gets married before 21, definitely they are not eligible for filing the 485 application. But otherwise, they are eligible for filing the 485 even if they move. But yes, the kids need to learn what an F1 is. The kids need to learn what an H1B is. They need to do it in 10th grade, 11th grade, and 12th grade. Just like the way they will understand what a college admission is, that when is the time to apply, you need to write the exams. You need to write whatever ACT, whatever that exams are, and you need to prepare for it. They also need to understand what an I-20 is and how to apply for a F1 visa. All those things, they need to understand it. Very similar to the admission process of the college, they need to understand it. We want you to educate it. We want them to tune in to our channel, these kids, so that they understand the process, not just what you tell them, but they need to understand. With the admission process, yeah, of course, you will educate them a little bit, but the kids will learn that there is an admission process. You need to apply the exams. You need to write the exams in 11th grade, not in 12th grade, and you need to prepare the application and all those things. In similar fashion, they need to be educated on what an F1 is, what an H1B is. Anything else, Emily?
All right. Yeah, last topic. With the job market the way it is, we're seeing layoffs still, particularly in the tech industry. People who are on H-1B are being laid off. Some people have the green card EAD. What are the pros and cons of using that green card EAD and just letting the H-1B go? Which one is safer right now?
There are some pros and there are some cons. Definitely, EAD is easy to obtain. They don't ask employer letters, they don't ask vendor letter, they don't ask contracts, service contracts. They don't even ask whether you're employed or not. They don't ask for specialty occupation. They don't ask anything. All they ask is, are you John Doe? Are you not? Are you sure you are? And then they also will check whether your 485 is pending. Simple. Those two things are answered yes, you get the 485 EAD. That's it, C9 EAD. That's all it is. That is an advantage of the adjustment of status EAD. Now, there are some disadvantages, especially recently they removed the automatic extension of the EAD. However, you can file the EAD within 6 months of expiration. And you can do one other thing. I mean, you can file more than 6 months in C and file one more time within the 6 months span. That you can do it too. And they're giving for 18 months right now, unlike before they were giving for 5 years. So there are a lot of people who are on adjustment of status EAD for 5 years. So definitely the extension, 540-day extension is a weak point. Sometimes there may be some gaps in the employment, but I'll be very surprised if that happens. That is one disadvantage to be on the EAD, letting H-1B go. The other disadvantage is what if the 485 gets denied for some reason? Definitely you will be out of status, then you'll have to leave the country and you can't come back because you can't change the status to H-1B if the 485 has been denied if you do not maintain the H-1B. Now, what the advantages of the EAD is, and if you don't maintain the H-1B, just EAD alone, is if you want to switch the employer, there's no paperwork required. No filing, no LCA, nothing is required. You just take the EAD and you show it to the employer. That's it. That's all the requirement is. Also, if by any chance you are not going to get the job, to get the green card going, though, you can be self-employed on the adjustment of status EAD. What are you speaking? How can I be self-employed? Is that true, Emily?
Yeah, absolutely. Self-employment is allowed for AC-21 portability.
That means that if I lose the job with company A, let's say Amazon, and then it's more than 180 days, I can do freelancing and self-employed in the relevant profession, still get the green card?
Absolutely.
Well, that's an advantage for the EAD. H-1B has a lot of restrictions to get it. Of course, there are some self-employment H-1Bs, but there are a lot of restrictions on them. So it's pretty flexible EAD is as compared to. And then EAD also allows for you to do the main job. And on the side also, you could do some business on the EAD. It's allowed to it. And to, let's say, for example, you want to manage a restaurant. Of course, you have to have the main job in the relevant field. On the side, you can do these things. Those are the things you can do on the EAD. So they are definitely an advantage. When it was my time, Emily, that I have to let go non-immigrant status and be on the adjustment of status EAD, I did let non-immigrant status go and was on EAD. Now, given a chance again, if I come back to the same situation, I will do the same thing in the Trump administration, though, because it was so flexible on the EAD. I can do anything I want. I was an immigration lawyer on EAD. And I even went to the 485 interviews as a lawyer. The client asked me the question, Rahul, when did you get the green card? I told him, I will tell you later. You know what I did, Emily? After the interview, I told him, I didn't get the green card yet. I'm still waiting. Because I told him before the interview, that guy would have rushed out. I don't want you as my lawyer. That was a long time ago, guys. So anyway, those things are allowed on the adjustment of status EAD. So it has a lot more flexibility, guys. So it's up to you. Yeah. There are some advantages to be an H-1B, especially if the 485 gets denied. And if there is any gaps on the EAD, that's where the H-1B will come into the help. Anything else?
All right. Yeah, we can go to questions now.
Questions, what documents are required to file the 485? My priority date is current. Oh, that's very good. Well, not much documents. I'd like to tell you that the documents that you normally don't encounter when you file a H1B or H4 is medical that you need to get it. If your priority date is current right now, you're going to file the adjustment of status in April, go rush to the doctor right now. Now, there are a lot of people who are asking, hey, my priority date is not current in April. Can I go get the medical? Don't do it right now. It takes only 1 week to get the medical. So why hurry up? Now, of course, you need a birth certificate and marriage certificate, which but marriage certificates you have been providing for H4 also anyway. So, but a birth certificate is something that you need to get it. And if you don't have a birth certificate, you have to get a non-availability certificate. If there is any discrepancies in the birth certificate, please contact a lawyer who is more familiar with Indian birth certificates, especially the people like me or anybody else, because then we are more familiar with how the Indian system works. So get the birth certificate. The birth certificate has to be from the municipality, or we call mandal, or in some cases, gram panchayat. These are the things the birth certificates are allowed. Now, if you are from Andhra Pradesh or Telangana, it's called Me Seva or E Seva. You pay 125 rupees, you will get the birth certificate. It's so easy to get it from them. If you don't have it, get the non-availability of the birth certificate, and 2 affidavits are required. If the birth certificate is registered late, not a big issue. You can always supplement with Aadhaar card, PAN card, ration card, election card, and other documents you may be having. Not all of them, but some of those things. So these are the two main things that I see when I file the adjustment of status. I don't have to tell you that you have to provide a passport, I-94, all your status requirements and all those things. I don't have to tell you. I don't have to tell you that I-140 is already there with the company, so they will already provide. So these birth certificate and medicals are the main thing. Yeah, passport photographs. One thing I forgot it. You need to get passport photographs.
Nitin says, if your 485 is pending and you have an EAD and AP, can you apply for H4 and H4 EAD through your spouse? So you need to be maintaining a non-immigrant status in order to file a change of status to H4 and H4 EAD. I'm assuming your spouse is maintaining the H1B. But if you are no longer maintaining your non-immigrant status and solely relying on the EAD, the only way for you to get an H4 is to exit, get the visa stamp, and come in. There are no visa appointments available. But if you are maintaining your non-immigrant status, then yes, you could, even though you've been issued an EAD AP. You don't have to use those.
Emily, I want to debate with you and I want to inform you something that I got RFEs today for H4 EADs. 6 RFEs I got from the daily Zoom call, though. And then I got some emails. I want to see what these RFEs are. There are some people who got an RFE online. They're just telling that, oh, you got an RFE because we will be requesting you to come for biometrics. You will get another request for the biometrics. This is just a delay tactic for the H4 EAD, Emily.
Oh, for sure. I mean, this is based on the December announcement where they said they're no longer going to accept your photos that you submit to them because they can't be sure that that's really you. You're not vetted enough. So in order to vet you more, they are going to make you come in to take your photo and use that photo on the new EAD card. And it is causing additional delay on those EAD applications. The most recent ones I've seen where we filed the H1, H4, H4 EAD, H1 and H4 were both approved in premium processing. It took another 6 weeks for the biometric appointment to actually be scheduled. And then after the biometrics, it's going to take who knows how long for the EAD to be issued. So this is definitely another delay tactic.
So we strongly recommend, if you want to get the H4 EAD, to file a writ of mandamus. They're supposed to approve this within 1 month or 2 months at the maximum they should take. So you can contact our office if you want to get the EAD expedited. You can send an email to info@rnlawgroup.com. Okay.
Does USCIS still honor the 60-day grace period, or is it discretion to reject a transfer for those who lost their job? So I have not seen them use their discretion to not honor the 60-day grace period. I did see one request for evidence where they brought that up in a change of status to B2. But the outcome of that case had nothing to do with the 60-day grace period. So as of now, no issues with them using and applying the 60-day grace period from your last date of employment to the day that you file your transfer or your change of status.
Sandeep Kumar's priority date, EB-2 priority date is January 15th, 2015. Is he allowed to file the adjustment of status, EAD at AP? Yikes. Unfortunately, it has to be a day before January 15th. So no, you cannot file the 485. Hopefully so in the month of May, you should be able to, but right now you cannot.
Abhishek says, my L1A extension is pending and the 485 date becomes current. Can we file adjustment of status? Is there any problem on the underlying non-immigrant status? So for an L1A, if your I-94 has not yet expired and you filed maybe the L1A extension early and it's just pending, no problem with filing the 485. You're maintaining your L1 status pursuant to your unexpired L1 and just have the extension pending. And that filing of the 485 has no negative impact on the L1 extension because L1s are dual intent. You can be pursuing the green card and be on L1 at the same time. Now, if your I-94 has already expired and you're staying based on the pending L1, then it's a judgment call of how confident do you and your company feel that your L1 extension is going to get approved. If you file your 485 and the L1 extension ultimately gets approved, everything's fine. No worries at all. But if you file the 485 and then for some wacky reason your L1 extension gets denied, it will cause denial of the 485 because you failed to maintain your L1 status up to the time of filing, because that time after your I-94 has expired, while your L1 extension is pending, you're technically not in L1 status during that time. You're in a period of stay authorized by the Attorney General. And for AOS 485 filing, you need to be maintaining an actual non-immigrant status at the time of filing, specifically for employment-based 485s.
Can I file 485 when on H4 application, or does it have to be H1B? Emily just said that you have to maintain the non-immigrant status. She didn't said H1B. So even if you are in H4, if you are the main applicant, you can file the 485 application. Now, for the 485 application, especially for EB-2 labor certification through EB-2, and for the EB-3 labor certification, EB-3 applications, though, you require the employer to cooperate with you, and they have to sign a form called I-485J supplement to file the 485. Otherwise, you can't. So if you have an I-140 approval with company A, and if you are working with company B, can you file the 485 with company B? No. Unless the company A cooperates with you, you cannot file the 485 application. Now, what if you are an H4? Can the company cooperate with you to file the 485 application? Absolutely, they can. What if you're an L1? What if you're an L2? It doesn't matter. What if you're an F1? Whatever visa status you are in, if the company cooperates and has an I-140 approval, you can file the 485 application.
Nirvana says the I-485 is in progress in the EB-1A category, filed in December 2025. My spouse got the EAD, but no movement in my case. Is that normal, or can they progress separately? That is normal. I mean, it's not normal, but it does happen. There's no rhyme or reason to it. I have a case, the exact same thing happened. The main applicant's EAD is still pending, but the dependent spouse received their EAD this week. It's just, government inefficiency at its finest.
Right now, my priority date is current. My wife is stuck in India and she cannot come here because of the visa stamping. Can I file the 485 right now, or should I wait for my wife? It's a very tough question, because if you get the green card approved, though, then your wife cannot come on a dependent H4 visa. So it's kind of thing where you need to look into. There's also something called counsel processing. So I would want you to evaluate. I want you to evaluate. I was discuss with the lawyer to see what are the options. Should I go for the consular processing? Should I file the adjustment of status myself? Should I wait for my wife to come in? There are a lot of things to be evaluated. Now, previously, we used to do something. We used to file a 485 without medicals so that they don't give the green card to the applicant, so that your spouse can come on a H4 visa. But that option is not there. The reason that option is not there is because they don't accept the adjustment of status without medicals. So you still need to discuss with the immigration lawyer to evaluate what is better for you. And it's not like one thing will not be an answer for everybody.
IT guy 007 says my priority date is December 2013. Filed the 485 in EB-3. Also have an I-140 approved in EB-2. Should I file the transfer of underlying basis from EB-3 to EB-2? And what is the process? The current process is to submit a supplement J, which means it requires the employer's signature. And whether you should or shouldn't, I mean, Raul always talks about kind of driving in LA traffic. You get in one lane and your lane slows down, and then the other lane goes faster. So you jump over into the other lane because it's going faster, and then it slows down. The best time to do a transfer of underlying basis is when the final action date is current in the category that you're looking to change to, but it does require the company's signature on the supplement J with that particular I-140 approval notice receipt number mentioned on it. We do a lot of them. I don't see a downside to doing it in most cases. It doesn't mean you're stuck in that category forever. We have a lot of people that downgraded in 2020 to file the 485, and then they upgraded to EB-2, and then they downgraded again to EB-3. You can move back and forth as much as you need to. So it's really a personal choice there, but I'm all about getting the green card as fast as you can. And the only way to do that is when your final action date is current.
Landy 5653 has this question. Prior date is currently pregnant. Can the medical, can I skip a couple of those things deferred due to pregnancy? Since pregnancy, these things are risk. Absolutely, you can. Not a problem. USCIS will be fine. They won't reject your application. Please file your 485 application, even if you are pregnant. Even if you're the primary applicant, file the 485. Even if you're a dependent, you file the 485 application. The doctor can request any exceptions. That's fine. They will issue an RFE later on. And then after, when your delivery is done, when you're physically good to take any of those things, you can take it. No problems at all.
Chris says, how can I find out where my 485 application is being processed to send the medicals? And do I also send my 485J to the same location? The 485J has a different filing address, so you don't send them to the same location. As far as where your application is being processed, so you need to check. Normally, when you get your receipt notice at the bottom left-hand corner, it says where that case is pending. You need to check your online case status to see if they have transferred it to another location. When they do transfer it, they're supposed to send you a notice of where they're transferring it to with a new location on it. They don't always do that. You can always try to do a live agent chat with USCIS customer service to see if they can tell you where it is. But normally you get notices whenever it's transferred to a new location.
Virama has this question. I'm a Canadian citizen on H-1B visa until 2020. I'm changing companies by the end of May, beginning of, is it traveling to India or Canada advisable? No, absolutely not. We don't advise anybody to travel right now. That's a blanket rule, guys. We've been doing that since February, March of 2025. And there are a lot of people who followed our directions. They're doing very good. There are a lot of people who didn't follow our directions. Man, oh man, they are in big trouble in India. Some of their visas got revoked. Some of them went for visa stamping, did not came in. A lot of troubles. Now, there are some people who didn't follow their directions. They came back safely. I'm not telling that didn't happen. But we want our clients to be more safer, better safe than sorry. That's how we want to be. So definitely do not advise anybody to travel.
Um, Question says, my final action date is current under cross chargeability. My 485 was submitted this past week. When can I expect my application to be approved? This is in New Jersey. So the normal processing time on the USCIS website is about 11 months. The average processing time, according to their December and January statistics, is right about 9.5 months. So somewhere in that range, but we're getting approval sometimes in 6 months, sometimes in even 3 or 4 months. So it's all over the board. No rhyme or reason to it.
Um, the question from M4663, my case remains pending. Looks like the processing is complete, but I've already submitted the medicals in 2023. I'm assuming you did before November of 2023. No, if the medicals are submitted before November of 2023, they cannot adjudicate, they cannot approve your application because medicals have expired. Now, an interesting question that is coming from the people like, I changed the location. My labor certification was filed from New Jersey. I'm right now in Dallas. Can I file the adjustment of status? Now, there are two kinds of applications. One is consulting companies, like, for example, Deloitte, Cognizant, or some other, these are consulting companies. They normally have documentation that you could be working from any location in United States. So they are fine. If it's a full-time company, though, if you are working at a different location, I want you to contact an immigration lawyer before you contact the company. Here is the thing, though, because as long as the employer and the employee are anticipating that you're going to move your job once you get a green card back to the location where they filed, where they set the location, that, let's say, New Jersey, for example. You are going to work in New Jersey, let's say Newark, New Jersey. So if after you get the green card, you promise you will go to the New York, New Jersey, and your company is okay with that thing, you could file the adjustment of status. A lot of big companies are willing to file that adjustment of status. Some of the companies may want to have you give in writing an affidavit that you're going to move back to New Jersey once you get the green card, which if I were you, I would give the green card, because you don't want to continue listening to this channel for the next part of your life. So definitely, I would advise that if the be cooperative with the company lawyer on that part, though. But yeah, you may want to discuss, if there is any little bit here and there. It's better to discuss with a private lawyer to understand where the employer is going, where the HR is going, where your company lawyer is going, or even before you approach them. It probably is better that you approach an immigration lawyer privately, so that any words what you said are not recorded, and then they may commit you for those things, and some of the companies may not want to file the 485 application for you. Just be careful on those things. But I would say most of the FANG companies are willing to file the 485, even if you are not at that particular location.
Monica says we have a pending 485 and EB-3 with an old employer and approved EB-2 I-140 from the new employer. Priority date is May 2014. Do you recommend to file a new 485 or interfile? Well, the first question is, are you still maintaining your non-immigrant status? Because if you're not, then filing a new 485 is not an option. But if you are maintaining your non-immigrant status, many, many times we see that the filing of a new 485 is a much smoother, faster process based on an approved I-140 versus waiting out, trying to get their attention on the pending EB-3 case and doing the transfer of underlying basis. So we tend to see faster results with new 485 filing instead of transfer of underlying basis. Obviously, that's more in filing fees, so that's something to consider. And also, it only works if you are maintaining your non-immigrant status while your old 485 is still pending.
Is it necessary for the H1 candidate to be in India to have their family's new H4 stamped? No, it's not necessary for them to be in India for them to get stamped. What are your predictions for the renewal of slots in 2027? I don't know at this point of time. They're not giving any information right now. Those whose visas are expiring in July 2027. Our advice is that if you are in USA, do not travel. Period. Do not travel, guys. Wait until this administration is gone, and then you can evaluate at that point of time. Because one thing you need to understand is this administration does not like H-1Bs, does not like the H-4s. Now, you may ask the question, why did they move the priority dates? They're mandated to move priority dates. They are mandated to give the green cards to the people who are eligible for. It's not something that they want to do it, but they don't have an option because there is 140,000 green cards they need to give, because there is some extra green cards that came in from the family immigration they have to give, because they are expecting more green cards coming in the coming year. They are anticipating to take more applications. So it's not like they want to do it, they have to do it. Now, the administration, whenever you cross the border, though, that's where the problem comes in, is that they have more authority to deny your entry into United States one way or the other. They stopped doing the third country nationals. That means you can't go to Mexico and Canada. There is no drop box, which most of the people would have gone for the drop box, would have avoided the problems. Then they have this vetting process. I don't know what this vetting process is. I mean, it's like, I don't know what this vetting process, but I know only one thing, that they just want to delay the entire process. So all these things, they're trying to do it now. Even if you have a visa appointment, assuming you're telling that your family is going to go and have a visa appointment, how many times have you seen them canceling it? How many times have you seen them postponing for the other people? So definitely, I would not send my family to the outside the country, though. I would not do that, even if you get the visa stamping appointment. Now, if they're outside the country, now they don't have an option. But if they're inside, don't do that.
Drew says, what issues can someone face moving from H-1B to H-4 and back to H-1B after a layoff? The biggest issue is the length of time that it takes to get the H-4 approved, particularly when it's a standalone change of status application. Based on what we're seeing in some of the recent B-2 to H-1B cases, if your H-4 is still pending when you get the new job offer, you may need to delay filing the H-1B until the H-4 gets approved. Because if you file the H-1B change of status based on the pending H-4, you might just quickly get an RFE saying we need the H-4 approval before we can approve the H-1B. And if you don't have the H-4 approval in time to respond to that RFE, the H-1B can be converted to consular processing because you don't have proof that you were maintaining your H-4 status at the time of filing, since it wasn't approved yet. When an H-1B gets converted to consular processing, the $100,000 fee kicks in. So for that reason, the biggest issue is just delaying your ability to get back to H-1B due to H-4 processing times.
Grad date is current in April. My daughter turns 18. We recently renewed her. Should I send a new passport copy to USCIS? Yes, absolutely. You should send the new USCIS copy. Now, we want to remind the people whose kids are between 17 and 21 who are filing the adjustment of status in April, though, because there is a change in the Child Service Protection Act. Previously, if I-140 is approved, if the filing dates were current, if the child is under 21, you file the 485 application. Yahoo! That means the kid is protected under the Child Service Protection Act. But Trump administration came in and changed the rules to say that the final action date has to be current for the child to be protected. So if this 18-year-old child becomes 21 and the final action date doesn't become current, the child gets kicked out of this application. So I normally tell people, unless a person is protected by the Child Service Protection Act, we have a huge. If you don't know what that is, we have a YouTube that we did on Child Service Protection Act. You can watch it. But for all the people whose final action date is not current, if the child is between 16 and 21, you need to watch those things very carefully.
And next week, Stephen Brown and I are actually doing a webinar just on Child Status Protection Act for kids that may be at risk of aging out. It's a free webinar, so feel free to join that. You can get the details on our website or on any of our social media. And Nilanjan wants to say that his wife's H4 EAD was pending for 4 months and she was about to lose her job. They tried the expedite request, but that didn't work. At the end, they ended up working with Stephen Brown in our office to file the lawsuit and litigation, and that was successful. She did get her H4 EAD. So congrats. Yeah, the litigation is working, and it is one of the few things that does work because expedites are maybe 1% of those work. Contacting your congressman or senator, they'll just say, well, it's in the normal processing time. There's nothing we can do. So if you are in that situation where the H4 EAD is being delayed, definitely consider litigation for that.
My priority date is March 2015. My company is contemplating and filing an EB-2 to EB-3. Do you recommend still to proceed? Yeah, I'm going to proceed because you're not going to lose anything. You still have the EB-2, you still have an EB-3. That's a good part about it. What if the EB-3 becomes current? So definitely I'm going to proceed with it. Whenever I don't see any loss, just a little bit finances, if there is a chance of benefit, I will tell people to take it.
AR Kid says, is litigation an option if the medicals are expired? The 485 was filed in 2020. Priority date became current in April. 2022 medicals must be expired. Where do I send them? So yes, you can still litigate even if your medicals are expired. In that situation, the litigation often triggers an RFE for the medicals to allow you to send them in so that they can then adjudicate the application. You can also do the interfile process that needs to go to the service center or field office where the 485 is actually pending. And that is going to be based on whatever the last notice you received from USCIS will typically have the location where the case is pending.
Common Man has this question. He has submitted EB-2 485, got an EAD in 2023. Unfortunately, he got a stroke. If I submit the medical again, do you think so it's going to impact the GC? Absolutely, it's not going to impact negatively. What they are looking into the medicals is contagious disease, AIDS, something like that. So assuming you have some of these heart diseases, if I sit next to you, will I get it? No, I won't get it. It's not contagious. So since it's not contagious, you don't have any problem in submitting the medicals again. In fact, since you submitted the medical previously, they expired. It's mandatory for you to submit the medicals again. No, because it's a heart issue, it is not a contagious issue. People who sit next to you, people who work next to you will not get that whatever problem you have. So you are fine in submitting the medicals again.
Deb from X says, what is the current wait time in getting the H-1B receipt number when you file for an extension? We typically receive it within about a week. In premium processing, we usually get at least the email notification within a couple of days. If it's been more than a week and you still haven't received it yet, you can have your employer check their bank account or their credit card statement for whatever, if they use the G1650 or G1450 to make the electronic payment. Those usually happen within a few days of filing. So if there's no payment deduction yet, there might be an issue.
Birth certificate previous to 1987, digitalization is restricted. It is originally handwritten birth certificate or non-available certificate. Yeah, I mean, if it's as long as it's been issued by the proper authorities, even if it's not digitalized, it's not an issue. It is acceptable. And if your birth certificate is in your native language, you need to get a translation and also a notarization that the person has knowledge of the local language, whatever the language it is, and of English. And it's a notary that you can always go to some private organization. They'll charge $30 or $50 to get it done, or you can do it by yourself too. That's up to you if you have knowledge of both the languages. Now, a lot of people ask question that I'm born in it says Warangal, but actually they're actually born in a particular town called Hanamakunda. Now, is that going to be a problem? No, I've not seen that as a problem though. Sometimes I see a mismatch of the birth certificate and passport. I've never seen that as a major problem though. If there is a date of birth mismatch though, that is going to be a very big problem. You need to consult an immigration lawyer. People ask questions. My last name is not spelled out. It's only initial. Is that a problem? No, it's not a problem. Sometimes we do see an RFE, they do see an RFE, then we provide at that point of time Aadhaar card, ration card, election card, PAN card, school certificate, hospital records, any of those things we provided at a later date. I normally don't like to provide it. So if also people ask the question, the spelling of my mother is different than that of what it is in my passport. Now, it depends on how different it is. If it is Savita, but it's been written as Padmini, then definitely that's an issue because there is no spelling nearby. Savita and Padmini are completely different. But if Savita is spelled Savitha in some places spelled as Savita, I have not seen that as a major issue. We can explain that because when the local language has been translated into written into English, each person writes it differently. So I've not seen that as a major issue at all. Yes, once in a while we have seen an RFE, we responded to it, but no issues in getting the approvals for the birth certificates.
Question from X. The H4 EAD standalone is pending since 2024. It's time to file the H1B renewal. Can I file the H1B, H4, and H4 EAD all bundled together now, even though the previous EAD is still pending? Yes, no issues with that at all. You can go ahead and do that.
How do I know whether I'm an EB-2 or EB-3? In general, I would just say that if you have requested to do it in EB-2, then most probably you are in EB-2. That recent request is what it counts, though. So the recent request is what it counts the most.
Ganesh says, are you seeing more chances of RFE if the I-140 is filed in premium processing? If it's a perm-based I-140 and EB-2 or EB-3, no, not really. If it's EB-1 or EB-2 NIW, yes. So I do not recommend filing those in premium processing.
I got I-140 from company A, later got rebadged to company B, but working at company A as contractor. Okay, that's I see. Can I file 485 without moving to company A? Wow, this is a tough question. Do I need to go back to company A when GC is approved? The first thing is that I don't know if company A is going to cooperate for you to file the 485 application. I don't know what you mean by rebadged. Is it like company B is a subsidiary of company A, or did the company A just put everybody in some contracting company not related to their own company and then move to a different company? If that is the case, though, where they are moved into a different contracting company, though, company A may not cooperate in filing the 485 application. But in this case, in the case where you're speaking about company A and company B, as long as company A is cooperative, as long as company A is willing to cooperate with you and they are willing to give the 485J supplement, you can file the 485. Absolutely not a problem.
Nomad says, do you see any improvement in perm processing timeline? 17 months is too long. No, there's no plans to improve perm processing timelines. Hopefully they don't get worse. I wouldn't put it past them, but there are no plans to make it any better, unfortunately.
Regarding the H1B to F1 change of status after the layoff, what specific evidences USCIS is prioritizing in RFE responses? I don't know what RFE responses you're speaking about, but in general, if you're filing the 485, if you're filing a change of status from H1B to F1, of course, you will have to get an I-20 with the service paid. You will have to show the financial evidence that you have money to support at least 1 year of education and stay in United States. On top of that, what they are looking very sincerely is what is the reason why you want to study right now? A lot of people will explain that, let's say, for example, I'm a lawyer. I work as a lawyer, and then later on, I want to move to India. And before I move to India, I want to develop my skills on the artificial intelligence, and I take some courses and I do join some things in the artificial intelligence. I can explain. Look, I'm a lawyer. I'm taking this artificial intelligence because when I go back to India, this artificial intelligence is going to be useful, even though I have stayed for a long period of time, studied Masters of Law in USA, but I did not have proper exposure for artificial intelligence. So I want to study artificial intelligence so that India's economy is booming, it is expanding, and with the self-sufficiency, with the Prime Minister started, they are going to do a lot of those things within USA, within India, and my skill is going to help there. So the main point is that what is the what is the assurance that you're giving to the USCIS that you're going to go back to India after you complete the F1? That is the most crucial thing that they are looking. The statement what you're making is the one that they are looking into.
Ravi says the H4 child's I-94 is expiring due to the passport expiration of the old passport. H1B transfer is pending. How do we extend the I-94? And is it required if the visa stamp is still valid on the old passport? Number one, yes, it is required. The visa stamp has nothing to do with your status when you are inside the US. It's the I-94 that controls. So if your child's I-94 is expiring, you need to either have them travel, which we don't recommend right now, or file an I-539 application to extend their I-94. Now, based on your H-1B transfer being pending, they can file the I-539 anyways, not a problem, but they need to include your I-129 receipt notice for your pending transfer. You may see an RFE on the child's H4 extension asking for the H-1B approval notice before they'll approve the H4, but you definitely need to file it before the I-94 expires, even if your H-1 transfer is still pending.
For a contempt of court order in divorce petition, does it impact the US naturalization process? I would definitely recommend that you contact a lawyer who is licensed in both the countries. That is me, Rahul Reddy. And there are some other people, not just me, but try to contact lawyers who are both Indian lawyer and also US lawyer. It's better that they take a closer look into what's going on that. Okay. A kid is a US citizen, mom is stuck with a kid. How do we get the mom in United States? Can we get a B2 for the mom? We recommend not to. There are a lot of people who are trying to contact us to see if we can get any emergency appointments. Now, there are some, you can request emergency appointment by yourself, not go through us. The reason is that even if you get an emergency appointments, the consultant says, okay, you're approved for the emergency appointment. Okay, give me the emergency appointment. We don't have emergency appointments. I mean, so if you're going to pay us the money for that, though, that definitely is you're wasting your money at this point of time. So please don't consult us if there is any development that we can get an appointment faster, or if there is a appointment slots that open up right now, we will inform you. But by having a consultation with us, that the expecting that we are going to get you a expedited appointment, we cannot help you at this point of time. Sorry. Anything else, Emily?
Looks like we are out of time. Thanks everyone for joining us. Make sure to sign up for our weekly newsletter so that you get the latest updates in your inbox once a week. You can do that by going to rnlawgroup.com. And of course, you can book a consultation with us or any of our attorneys here by going to rnlawgroup.com.
Thank you guys for tuning.